Good morning, students. So let's start with chapter Share Capital, Volume 2 book, Company Accounts. Previous lecture के अंदर we have already covered meaning of company and their characteristics, and today we are going to start difference between partnership and company account. So let's see what is the difference between partnership and company. What type of company? Joint stock company, यानी public limited company. So let's make a difference between these two. First one is mode of formation. So partnership business, it is established under the provisions of Indian Partnership Act 1932. But keep this thing in mind, registration of a partnership firm, it is not compulsory. A partnership firm may be registered or may not be registered. But in case of a company form of organization, it comes into existence only after registration. So here registration is compulsory and company is established under the provisions of Indian Companies Act 2013 or under the provisions of any previous company law. Second, regulatory act. Partnership business is controlled or regulated by the provisions of Indian Partnership Act 1932 and company is regulated under the provisions of Indian Companies Act 2013. Number 3, number of members, yani number of members. In case of partnership, minimum number of partners required are 2 and maximum they are restricted up to 50. But in case of company, minimum number of members, in case of public company, minimum number of members are 7 and maximum there is no limit. But in case of private company, minimum number of members 2 and maximum they are restricted up to 200, excluding its present or past employees. And in case of one person company, only one member may be there. Liability of partner is unlimited, jointly as well as individually. So individually as well as jointly their liability is unlimited. But in case of a company form of organization, the liability of a shareholder may be restricted up to the face value of a share, that is called limited liability company. Or second one, the liability of a shareholder may be restricted up to the guaranteed amount which he has committed to pay at the time of winding up. This such type of company is called limited by guarantee. Or third one, in case of unlimited liability, those shareholders' personal assets may also be utilized to pay off business debts. Next, distribution of profits. In case of partnership, profits earned by the company, partnership firm, they are distributed among the partners in an agreed ratio, or if there is no partnership deed, then in equal ratio. But under company form of organization, profits are distributed in the form of dividend as per the provisions of articles of association or declaration made by the directors. Then in what proportion profit will be distributed among the shareholders in the form of dividend. Next, audit. Audit means verification of books of accounts. In case of partnership, auditing is not compulsory or mandatory. But in case of company accounts, auditing is very much compulsory. Management. Business may be managed by, in case of partnership, business may be managed by all the partners jointly or by any one of them who will act for all. Or in case of a company, business is managed by board of directors who are elected by shareholders. Getting? So management is different and ownership is different. Transfer of share. A partner cannot transfer his share without the mutual consent of all other partners. But in case of public limited company, shares are freely transferable. But in case of private company, shares are not permitted to transfer. Business. A partnership can carry on any business if all the partners agree. So they can run any type of business. But in case of a public limited company, they have to carry only those business activities which are mentioned in their object class under memorandum of association. Winding up. A partnership may be wind up by an agreement or by the order of court, or in case of they are unable to pay their debts, partnership firm can be dissolved. But company can be established by following the process of law. In the same manner, if we want to wind up the company, again we have to follow the process of law, means legal procedure we have to follow to wind up the company. Last one is stability of the business. Though partnership firm, it is affected by death, retirement or insolvency of partners, but in case of a company, shareholders death, insolvency or transfer of shares, it does do not put any type of effect on the continuity of the company. तो दैट्स ऑल. आज के वीडियो लेक्चर के अंदर वी हैव कवर अप वन इम्पॉर्टेंट क्वेश्चन, दैट इज डिफरेंस बिटवीन पार्टनरशिप एंड जॉइंट स्टॉक कंपनी. तो दैट्स ऑल. बाय बच्चों.